So today in the Leon Valley case, the saga of the preliminary injunction trying to quash the warrants to get the data from Google, that is done as far as the district court is concerned. There will be no preliminary injunction. That does not mean that something else can happen. Maybe Google can raise an objection. The various criminal defendants can raise objections. They can file motions to quash it, or they can have it suppressed after the warrants are carried out, or there are options still. But as far as the district court in the 1983 suit is concerned, the preliminary injunction is now done. It's over. There's going to be no preliminary injunction. I suppose that the plaintiffs can file an appeal on it, but I don't think that's going to do any good. The controlling documents are the report and recommendation of the magistrate judge, where he said essentially that there is no good reason. He went through the various elements, the tests that are required in order to grant a preliminary injunction. This is the test, by the way, for those of you who are following along at home and capable of grasping it. There has to be a substantial likelihood of success on the merits. There has to be a substantial threat that irreparable injury will result if the injunction isn't granted. I think this number 2 is a loser. I don't think that the plaintiffs could prove that there would be an irreparable injury if the injunction wasn't granted. The third prong of the test is the threatened injury outweighs any harm that might result from the injunction issued against the defendants. Because there was not a substantial threat of irreparable injury, number 3 really doesn't matter. Excuse me. And 4, granting the preliminary injunction will not disserve the public interest. I think they also lose on 4. I thought that they lost on 4. If you go all the way back to my original analysis, I thought they lost on number 4. I do think it doesn't serve the public interest, because we need our police forces, if they get a judge to sign off on the warrant, then that typically means 99 times out of 100, or insert whatever random percentage you want here, that it is in the public's interest to have that warrant executed. And I know that there's going to be a bunch of people in here who are just going to, believe that the police are just all evil and judges are all in the pocket of big business, or in the pocket of police, or whatever your favorite conspiracy theory is. I'm sure that in your head you think it's well justified. The other big thing was the plaintiff's objections to it. I didn't think it was very compelling. I didn't go over it, but I didn't think it was a good winner of an issue in the first place. And so, looking at the facts independently, I just wasn't persuaded by the plaintiff's argument. But anyway, today, from the actual district court judge, he accepted the report and recommendation of the United States magistrate judge. Now, that doesn't mean that the plaintiffs have lost. It just means that they don't get the preliminary injunction quashing the warrants. It doesn't mean they've lost. So for everybody, if you post that whatever this is, that this shows that the judiciary is biased against the cop, or against the police, or against the people, biased against the people in favor of the police, or what have you, then you're being silly. This doesn't mean that at all. It means that the test wasn't satisfied. This test right here wasn't satisfied. The plaintiffs didn't show that these 4 prongs were met. That's all it is. It doesn't mean that rights weren't violated. It doesn't mean that the court won't end up finding in favor of the plaintiffs. It just means that the plaintiffs didn't satisfy these 4 prongs of the test to get a preliminary injunction. So take your chill pill, relax, and we're going to go ahead and read this. Because somebody said that I shouldn't just read these things verbatim. So I'm the kind of guy who's just going to read it. So grab your hot toddy, your beer, your wine, whatever alcoholic beverage of your choice. Sit back, relax, and enjoy an entertaining reading of a judicial decision. This is the order accepting report and recommendation of the United States Magistrate Judge. Before the court are the report and recommendation of the United States Magistrate Judge, docket number 62. See 62 right there? Concerning plaintiff's motion for preliminary injunction, docket number 46, along with the plaintiff's written objections, docket number 63, right there. There too. The magistrate judge found that the plaintiffs have failed to establish that a preliminary injunction is warranted at this time. The report therefore recommends the motion be denied. Where no party has objected to a magistrate judge's report and recommendation, the court need not conduct a de novo review of the report and recommendation. See 18 U.S.C. Section 636 B.1, which states, a judge of the court shall make a de novo determination of those portions of the report or specified purposed findings and recommendations to which objection is made. In such cases, the court need only review the report and recommendation and determine whether it is clearly erroneous or contrary to law. See U.S. v. Wilson, 864 F. 2nd, 1219 at 1221, Fifth Circuit, certiorari denied at 492 U.S. 918 in 1989. On the other hand, any report and recommendation to which objection is made requires de novo review by the court. Such a review means that the court will examine the entire record and will make an independent assessment of the law. The court need not, however, conduct a de novo review when the objections are frivolous, conclusive, or general in nature. See Battle v. U.S. Parole Commission, 834 F. 2nd, 419 at 421, Fifth Circuit, 1987. The court has thoroughly analyzed plaintiff's submission in light of the entire record. As required by Title 28 U.S.C. Section 636 B.1c, the court has conducted an independent review of the entire record in this cause and has conducted a de novo review with respect to those matters raised by the objections. After due consideration, the court concludes the plaintiff's objections lack merit. It is therefore ordered that the report and recommendation of the United States Magistrate Judge, docket number 62, is accepted pursuant to 28 U.S.C. Section 636 B.1, such that, because they have failed to carry their burden, plaintiff's motion for preliminary injunction, docket number 46, is denied. Notwithstanding the foregoing, nothing in the report and recommendation or this order should be seen as ruling on the merits of the plaintiff's 42 U.S.C. 1983 claims at this early stage. I'm going to read that again because idiots are going to be commenting about this, completely misunderstanding the point of this, and thinking that, I don't know, Turner v. Driver somehow makes this a bad conclusion of law and that this judge needs to be hanged or whatever. So I'm going to reread this so chowderheads can understand it and get it through their thick skulls that this doesn't mean the plaintiffs have lost. Notwithstanding the foregoing, nothing in the report and recommendation or this order should be seen as a ruling on the merits of the plaintiff's 42 U.S.C. 1983 claims at this early stage. It is so ordered, signed this 26th day of November, 2018, by Fred Beery, United States District Judge. So this came out precisely as I predicted it would, a long time ago, in a galaxy far, far away, and I got so many people thinking that I was wrong and stupid when the court initially granted the temporary restraining order. Oh my God, John, you're so stupid. You're just a family law attorney, and here we are. Here we are. Exactly where I thought we would be. Thank you for watching, and have a great day.